Hello students, topic for today's lecture is rule of law and the modern administrative law. Rule of law is classical principle of the administrative law. As a matter of fact, this principle was one of the principles that acted as impediment development of the administrative law principles. The irony further is that the rule of law is now an important part of a modern administrative law, whereas the rule of law is still the one of the very important principles regulating in the common law countries and common law derived countries. Modern laws has denied some of the important parts of the rule of law as proposed by Dicey at the start of the 19th century. Now we'll discuss about Dicey's rule of law. The concept of rule of law backs to the time of Aristotle. Aristotle ruled out the concept of rule under the discretion by all means and tried to convey his followers that given the choice, it is always rule of law that scores over rule of discretion. Then, in modern times, the rule of law was propounded by Albert Dicey, a British jurist and the philosopher. He gave following three postulates of the rule of law. Everyone is equal before the law. Second, sanctions have to be backed by the law. Third, courts are the ultimate body and the supremacy of the court is ambivalent in the civilized society. He was a firm proponent of the concept and very influential thinker of his times. Though the first two principles are still in almost every legal system of the world, the third principle were protested by many of the jurists at that time. The Dices, in particular, opposed the principle of French system of droit administration. England at that time was in fact propounding some quasi-legislative and quasi-judicial process which were taken cognizance of the English thinkers of that time. Still, the whole common law system of the country was blindfolded with the Dicey's philosophy of rule of law. Dicey's rule of law and modern administrative law. Dicey's view and the proposition of rule of law had succeeded in part and was not sustainable on the other. Most of the modern legal system implements the principle of judicial review and similar principles of the proportionality and legitimate expectations. Dicey's view on written and unwritten constitution are subject to much debate and discussion. What can be said is that some written constitution, let's take an example for that US Constitution, have been quite successful at providing a framework within which individual rights are protected, while others have been near total failures. The modern administrative law is fine mixture of droit administrative, the French legal system and Dicey's rule of law. The sophisticated combination of the two principles has given rise to the powerful and the vast body of the executive. In fact, the development of the modern administrative law is consequence of development of administration and its side effects. I hope it must be clear to you. Thank you.